Hello, good evening. My name is George Suji and I'm a student of Anglia Ruskin University, London. Today I'll be making a presentation on freehold covenant and positive covenant precisely. The title of my presentation is The Enforcement or Running of the Body of a Positive Covenant is Long Overdue for Reform. The first question is, what is a covenant? A covenant is a promise contained in a deed. A covenant may either be positive or negative in nature. Positive covenant imposes burden on a covenantor to carry out specific acts. For example, a covenant to construct and maintain a fence between two buildings. Negative covenant, on the other hand, prohibits a specific kind of activity. Take, for example, a covenant not to build an extension to an existing property. And a covenantor is one who takes the burden in the land, while the covenantee is the one who enjoys the benefit in such land. Now the question is, can a successor in title enforce the benefit of an original covenant? Under the common law, a person can enforce the benefit of a covenant if the following requirements are met. Firstly, he must touch and concern such land. The principle of touch and concern was given in the case of P&A Swift Investments Limited and Combined English Stock Group. This means that the covenant must benefit the land and not just for the pure personal benefit of the covenantee. And also, the second criteria is there must be an intention for such benefit to run. Where this intention is not stated, it is implied under Section 78 of the law, subsection 1 of the Law of Property Act 1925. And then thirdly, the legal estate must be held by the covenantee. Finally, the person claiming the benefit of such covenant must derive their title from the original covenantee. This principle was given in the case of Smith and Snipes Hall Farm Limited and River Douglas Catchment Board. The next question is, can the burden of a covenant be enforced under the common law? According to the current law, the burden of a covenant, either positive or negative, does not run in law. This principle was stated in the case of Old and Oldham Corporation 1885. Also, in the case of Ron and Steven 1994, Lord Templeman held that equity supplements the law and not contradicts the common law. Therefore, it's not possible to allow an agreement that was expressed between two current landowners to pass to a third purchaser who was not involved in such covenants. The impact of this decision is that there is a strict legal position of privity of contract. In talk, I must say, equity settled the position of the burden of negative covenant running to the successor in title. It held that 4 conditions must be satisfied. Firstly, the covenant had to be a negative one. Secondly, at the date of the covenantee must have owned such benefited land. And then thirdly, there must be an intention for such benefits to run. Where such intention is not stated, it's implied under Section 79 of the Law of Property Act 1925. And finally, there must be rules of registration of notice. The first problem that is noticed is that the enforcement of positive covenant was not addressed by equity. And currently, there are 4 indirect methods in which the burden of a positive covenant can be enforced. The first is the method of mutual benefit and burden principle. This principle was given in the case of Halsall and Brazil 1957. The principle states that one may not take a benefit without accepting the burden that goes with it. Therefore, it is possible to enforce an obligation to pay for the upkeep of a driveway where the obligee has and chooses to exercise such right of way over it. The second method used is a chain of indemnity covenant. This method of enforcement applies as follows. When an original covenant is entered into, a requirement is imposed on the covenantor to require an indemnity from his successor in title. If such covenant is broken, the covenantee can sue the original covenantor who remains liable in the covenant, and he in turn will be able to see his successor, and so on. The third indirect method used to enforce positive covenant is the use of leasehold. Section 153 of the Law of Property Act 1925 allows leases more than 300 years, in which 200 years is remaining to be expanded for the purposes of enforcing positive freehold covenants. The final indirect method used for enforcing of a positive covenant is the use of a rent charge. A rent charge is an annual or periodic sum of money payable to someone who does not own land, charged with its own payment. If a rent charge is coupled with the right of entry, the owner of the interest may enter the land to enforce the rent charge and also the performance of such positive covenants. The right of entry may be exercised not only for the failure to pay for the rent charge, but also for the breach of the covenant, subject to the court jurisdiction to provide relief and against forfeiture. In this way, positive covenants have been enforced. And the problems that we can see with the current indirect method are as follows. Firstly, with regards to the benefit and burden principle, the application is limited in scope. Also, the House of Lords held that there must be a reciprocal relationship between the benefit and the burden for such principle to be enforced. And also, the principle will not work where someone has no choice of accepting such benefits. And one final flaw with this method is that it's only relevant as long as the benefit is valuable to its successor entitled. The second problem we can notice with the chain of indemnity is that indirect enforcement of burden can only lead to an award of damages, whereas the covenantee may prefer an injunction or a specific performance. And also, the disappearance or insolvency of one party leads to a broken chain. And also, a party may refuse to agree to such indemnity contract, thereby making such process not work. And with regards to leasehold, this method, according to the Law Commission, is artificial, untested, its validity is untested, and it's subject to so many difficulties. And there's also an unnecessary expense in negotiating a lease. The final method was held to be cumbersome and hardly transparent. In 2011, the Law Commission in their work titled Making Land Work, Easement Profit Covenant, a project, held that the indirect methods of enforcing of a positive covenant is risky, as in the chain of indemnity, is unnecessary, as in the cost for leasehold, and is only for a limited period of time and uncertain. Holfin, in as far back as 1923, noted that the outdated references between the law and equity is a mistake, and one should look at the new law by taking overall view of both elements. His views has not been taken up to date. Also, Bernard Rodin in 1987, in his article, The Economic Theory and Property Law, The Numerous Clauses Problem, explored the practical and economic problems why burdens of positive covenants do not run in law. The reasons he observed were as follows. Such covenants do not run so as to protect buyers to only the fixed list of property rights when buying. Also, they need to facilitate development by resisting overburdening of property. He also noted that there's difficulty of ensuring that rights can be varied or discharged. According to Bernard, the reasons for not enforcing positive covenants are not particularly strong. He argued that by carefully integrating positive covenants into a registration system, the current problem will be solved. Also, the Law Commission in 1971 noticed that the contradiction between the rules of positive and restrictive covenants is illogical. One notable difference of such reasoning is that there's a difference. The law currently allows positive covenant to run with leasehold, while it refuses such for freehold. The Law Commission proposed a scheme for reclassifying positive and restrictive covenant as land obligations in 1991. This proposal focused on the central notion that the current law was inherently complex and contradictory. However, the report was rejected by Parliament in 1998. More recent academic analysis have sought to find a principled reason why the law should allow or prevent the creation of new property rights. It has been argued that such rights are desired and permitted in cases where it is better, cheaper, or fairer to create a right that will last, so that future owners do not have the cost of recreating it, than to create a transient right and future owners will want to remake it. The other side of the argument says that once a land has been burdened with an obligation that does not need to be recreated, when it changes hands, the land may lose value because there may be little or no scope to vary or remove the burden by negotiation. And so it has been argued that wherever the range of property rights has been widened, the effect has not been to eliminate problems, but to recreate them in different forms. Pamela O'Connor, the commissioner charged with reform of easement and covenant for Victoria Law Commission, has drawn attention to the problems of choice. She notes that the potential for oppression of particularly large-scale housing developments where properties are burdened with positive obligations which have not been truly chosen by their purchasers, since such obligations come with the package. And then finally, the Law Commission proposed in 2011 that positive obligations should run with land. The concern raised by the introduction of positive obligation is an open-ended obligation which would burden land, and the need to ensure that such burden is discoverable. According to the Law Commission, the following safeguards will be used. Firstly, the touch and consent principle will be used. This means that the positive obligation must benefit the covenantee's land rather than the covenantee personally. Also, the Law Commission suggested that by developing a functional definition of permissible proprietary positive obligations, this will help identify positive obligations and distinguish them from other interests in land. In addition, the Law Commission held that positive obligations which have become obsolete should be able to be discharged by the Lands Chamber, which is currently so under Section 84 of the Law of Property Act 1925. The impact of this recommendation is that future positive and negative covenants, as well as easements, will be in a single class, creating standalone property rights. Another impact is that positive obligation will only be able to run to third parties taking ownership while registered. The Law Commission suggested an additional requirement that an entry would have to be made on both plots of registered land. And the final impact of recommendation of the Law Commission is that positive obligation will take place as property interests. In conclusion, I believe that if the need for change is clear, as the current situation causes unnecessary problems for individuals who are seeking either to enforce covenant or sell land free from the restrictions that were intended to be either temporary or personal to the individual. If this proposal by the Law Commission is adopted, it will be a step towards a streamlined and effective land register. Thank you so much.